If you're being sued by a debt collector, you're going to want to pay attention to this video. Debt collector lawsuits are at an all-time high. Last year, there was over 4 million. The year before, over 4 million. As a matter of fact, since 2007, there has been upwards of 4+ million debt collector lawsuits filed against individuals who they purchased the debt from original creditors for pennies on the dollar. Now, I want to paint a picture in your mind, because one of the number one ways that people get into trouble when they with debt collector lawsuits, when they could have actually won the lawsuit, is they don't know what to do. But I'm going to paint this picture in your mind because this is what I see when people come to us for help. I want you to imagine a barbecue dinner. Nice barbecue, potato salad, some beans, maybe garlic bread or something with it. Now what I want you to do is I want you to put some eggs, some scrambled eggs on that plate, or a fried egg on that plate. I want you to put some cereal, a bowl of, maybe, I call them throat scratchers, Captain Crunch right there also. I want you to put some grits right over there. I want you to put maybe let's throw on a fried egg. Let's throw on some bacon. All of that stuff is good, and this is why I wanted to paint that picture. All of that stuff together is not good, but all of that stuff separate is very good. What I see a lot of people doing is they'll come to me and they'll say, Steve, I did this for the debt collector summons that I got. And I'm like, what you did is something that should be done, but you got it all out of order. See, it would be good to eat those eggs in the morning, and then you have the barbecue at night, and you have the other stuff in the middle of the day. But if you mix it all together, everybody's going to be like, what are you doing? It doesn't make any sense. And that's what happens with the court. That's what happens with the plaintiff attorney. They're like, Judge, we should just disregard all of this because this doesn't make any sense. So now what I'm going to do is I'm going to walk you through what you need to do, the things that you need to pay attention to, and why it is so important. Why is it so important to do this? Because you could lose by technicality. You could lose your case because you don't even know that you had to do something, simply because you didn't even really read the instructions, or of no fault of your own, you just don't know what you're doing. You just don't know what you're doing. And maybe you've reached out to attorneys, you reached out and it's like, we're going to charge you $1,500. And you're like, the debt is $1,500. Or the debt is $2,500. It doesn't justify, it doesn't make sense to you. Forgive me, I got a little bit of a cold, but I make the time to make these videos for you regardless. All right, the first thing that you need to do is when you get the summons, they might leave it at your doorstep. In some states, they're allowed to leave it at your doorstep. They just have to prove service. Some states, they just have to prove the service and not leave it. And that's even worse case because you don't even know what you're really dealing with. You have to go down to the courthouse to get a copy of it. And then in some states, you have to sign for it or they cannot move forward. So the first thing you need to do is find out if you did not get the summons in hand. Find out the rules on if they can proceed without it. In most states, they're going to be allowed to proceed without it because what they're going to do is they're going to publish your information on the internet. They're going to publish your information in a printed newspaper, and then they're going to proceed. So you can validate what I'm telling you. If you're being sued right now, type your name in. If you know who is suing you, the original creditor or the debt collector, type your name and put V, your name, space, V, and then space, the plaintiff's name, and you'll see that it's all public record. Like you're blasted on the internet for everyone to see. This stuff here does not have to go through any privacy as long as they put it through the court. There's no privacy stuff. They could be suing you as the wrong individual and your stuff is blasted out there like that. That's just the way the court system allows it to work. So first, you look over. Let's just say you got it in hand. You look over the lawsuit documents, and you want to look at who the plaintiff is. Who is suing you? What are they saying? Now, all of those points on there are the allegations on what they're alleging. Some of them may be just plain, like you live in this county, that they're suing you in the proper jurisdiction, that type of stuff. And then they're going to get to what they claim you owe, and then they're going to probably say you unjustly enriched yourself by taking the money, and you got all of these elaborate things. They're not going to say elaborate things, but they're going to use the word like enriched yourself off of their money, and you didn't want to pay the money back. They're going to use those type of words. The next thing you want to pay attention to is you need to identify the deadline, because it's typically 20 to 30 days that you have to respond, or they're going to be, in some cases, be able to get a default judgment against you because you didn't respond. There is a deadline. And if you miss that deadline, you are really putting the clamps down on your ability to be able to fight. So now the next thing, and this is something that you should do, but you should do it within your summons response. I see a lot of people get this mixed up. You should do a request a debt validation for that debt. Within that debt validation, you're going to want them to tell you how they came up with that amount, not just where they're going to attach some statements to say, oh, you owe this amount of money. You're going to want them to prove how they came up with that amount of money, especially because it's a third-party debt collector. They're just really taking the word of the original creditor without looking at any other documentation that they have. Now, I'm gonna tell you, they could have documentation proving that you disputed stuff with your account, or they could have documentation that does not add up to what they're claiming that you owe. But they don't care. They don't care because most people don't know they have a right to request those documents. It's just like if you've seen cases out there where they were like, the prosecutor did not make these documents available. Well, if you don't know about those documents and you don't know that you have a right to ask about those documents, what are you going to do? Like, what can you do about something that you don't know? If you don't know you have a right to ask for it, you don't know. And they play on that. So they're like, we're just going to keep it with the amount that you owe. We bought it from this company, give it to the judge, put a few statements on top of there, put the documentation on how we got the debt, and let's just move on. You got to pay this debt. When it's a whole lot more than that. They have to prove how they got to that amount. Now, the next thing is you need to prepare an answer to the debt collector lawsuit. If you've been watching my videos, you know one of the things that you should always do when you're dealing with a debt collector who purchased your debt from the original creditor is you need to make sure that that debt is not past the legal statute of limitations to collect. If it is past the legal statute of limitations to collect, they are in violation because there is no legal remedy for a debt that is past the legal statute of limitations to collect according to the laws of every state in the United States. Now, the tricky part is that there's different, the statute of limitations is different for specific types of debt. Like opening accounts is usually shorter, like credit cards, payday loans, communications debt like cell phones, cable bills, that's usually shorter. Written contract is usually longer. But if it is past the legal statute of limitations, They cannot bring you to court. They're in violation. You might be saying, well, Steve, why would a debt collector take me to court for a debt that's past legal statute of limitations? Because they don't expect you to know, they don't expect you to question it, they don't even expect you to show up. And yes, the CFPB, the Consumer Financial Protection Bureau, has filed lawsuits against several debt collectors who brought people to court, sued them over debt that was past the legal statute of limitations to collect. Now, they can call you, they can try to say morally you should pay, they try everything, but you don't have to pay it legally, and they cannot take you to court over that debt. The next thing is, if you checked your state laws on service, you need to check to see if you were properly served. Because if you were not properly served, that could be a defense to get the summons, the case dismissed. But you have to do that in your response. Like, you can't just say, oh, I wasn't properly served, and you don't respond to the summons. You have to respond to all of it and put in there, I was not properly served. The next thing is lack of standing. I see this, and as a matter of fact, I don't have it right here in front of me. I used to see this a lot of times, where the debt collector pretended to be the original creditor to make it look good when they filed a lawsuit, when the original creditor had nothing to do with the lawsuit. And so whenever we saw that, we would say this is lack of standing, because this is not the collector did not provide sufficient proof that they can bring this case, because they actually put a creditor on there that is not part of this case. So at best, they have to flip that over and refile it and put their name there, because the original creditor is not bringing the case. There's other circumstances that can also bring in that the debt collector does not have a legal right to collect on the debt, because they did not provide sufficient proof that they have a right to collect on that debt. So the next thing that you got to do after you do all of that, you get your answer put together. So you're answering the affirmative, you're answering the allegations against you, each one of them, even if they're true. You just say you admit, like you live in that county, and then you put together your affirmative defense, and you also ask for it to be dismissed. So you're going to have all of your points on what you believe should, on your reasons on why this case should not be brought, and things that you want to challenge with their documentation with the case. Do not try to go out there reaching all these other cases and throwing them into your case. That is just going to get you mixed up. That's just going to prolong it. You want the judge, you want the debt collector attorney, and you want the judge to make determinations based off of the documents that they presented, and a lack of documents that they did not present that are required for them to prove their case. If you stay within that framework, you will be very successful with getting a lot of debt collectors to bag out even before they go to court. All right, so now the next thing that you got to do is, you got to, once you have your court date, first you package up everything, make sure that it's structured the right way, and you can look at how they gave you your summons, and you can structure it that same way. And then I tell everybody, you should take it to the courthouse, and you should file it with the clerk and ask the clerk how should it go to the plaintiff attorney. Some of the times they upload it and the plaintiff attorney gets it electronically. Some of the times they say you need to send it. If you send it, you need to send it certified mail. Send it certified mail, because if you don't, they can play this game saying that they did not receive it. You know, that the games start to get played when you respond the right way and you do the right things. The games start to get played. So now, once you file it, you'll usually get they'll say that they're going to have a hearing date, and you need to make sure that you make that hearing date. In some instances, they could dismiss the case outright from the beginning. Most of the time, what I've seen is that they will, if they're going to dismiss it, they'll at least go for one more shot to see if you're going to show up, because they get a default judgment if you don't show up. They don't even have to hear anything on what you had for your defense if you don't show up. That they'll just wait to have your name called. Now, the reason why they'll do that is because they're going to be there already for other cases. They're not just going to be there for your specific case. So they're already going to be there. So they'll be like, hey, just roll the dice. If they stand up, then just say dismissed. If they don't dismiss your case, then the judge is going to hear it. But if you did this the right way, you would have the information in your defense, and you would be able to have that. Number one, if documents were not presented that you had in your defense, the plaintiff attorney should be ready to have those documents. If they don't have those documents and they don't have stuff to prove their case fully, then you should ask the judge to dismiss the case and dismiss it with prejudice. Some of the times they might try to allow them to get more time to get more documents, but this is the game that they play, and I've seen it to where they've played it to where they put the court date a year out. Like, it's like, why don't we take care of this now? You want to put it a year out, and your options on that, if you put your response together the right way and you have a good chance of winning, and they try to say, well, we want to put it out a year, then you need to motion to dismiss the case. You need to. That's when you would take proactive action to be able to get to stop the debt collector from being able to just try to run the clock out on you, either forgetting or not, forgetting that you got to go to court, or just to where they just wear you down to where you want to settle when you are in a good position of winning. All right. So if you have debt collectors who are suing you, I invite you to go to my website, thecreditrepairshop.com. There's a little live chat button that's on the bottom right or left or in the middle, depending on what you're looking at this video on. And then put your summons in there. Just upload it as a PDF and tell us, a little bit about what's going on. Leave your contact information. We'll follow up with you to let you know how we can help you. If you already know that you want to get help, there's a link below this video also that you can go to and get the service, and we'll have your summons response either same day or next day. Want to make sure that you get help. You will have the opportunity to win your case. We are not attorneys. We do not give legal or accounting advice. This is a tool that we've put together to be able to help people just like yourself, like I had to help myself in the past, and all of the other customers, and you'll see examples of those on the website, to be able to fight back against debt collectors. And I don't think that there's anything wrong with that. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website, YOUR, the number 3, like 3, scores.com. Grab your TransUnion, Equifax, Experian credit reports, and all 3 scores. If you have debt collectors coming after you early so you don't have to end up going into court, remember I told that picture of all of that food? Well, the first thing that you should do is when they send that first letter, if you do this properly, you can stop the debt collectors from even getting into the lawsuit phase. Go to my website and grab statute of limitations letter, debt validation letter, cease and desist collection activities letter. Use the one that's appropriate for your situation. I do ask for a donation on those. I really appreciate those people who do. It helps me monetize my time here to give you this very valuable information. Thank you for your time. Like this video, share this video, subscribe to my channel, post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.